over to Judge Yandel.
I just want to make sure that we let everybody recognize that presiding Judge Yandel is actually, that's not just the screen name for now, and that's not just a fake background. You are being overseen in this final round by the Honorable Judge Stacey Yandel from the Southern District of Illinois. So have a fantastic competition, all of you. Good luck.
Okay, with that, I believe we are ready to proceed. First of all, this is Chris Jordan as the personal representative of the estate of Thomas Jordan versus Knight Property Management, LLC, case number 19 CV 1014. This case is called for a jury trial. Before we start, I would ask counsel to just introduce yourself by name only for the record, beginning with counsel for the plaintiff.
Good afternoon, Your Honor. My name is Seth Wax, appearing on behalf of the plaintiff, Chris Jordan. Today, I am joined by my co-counsel.
Good afternoon, Your Honor. Sarah Stebbins, also for the plaintiff.
Thank you, counsel.
And good afternoon or good evening, Your Honor. My name is Taylor Maurer, and I, along with my co-counsel,
Your Honor, my name is Sam Heyman.
we represent the defendant, Knight Property Management.
Okay, thank you, counsel. Again, before we proceed, have the parties requested brief feedback at the conclusion of the proceedings?
Yes, please, Your Honor.
Okay, done. All right. Does the plaintiff have a motion in limine for the court's consideration?
We do have a substantive stipulation that we've been able to come to with opposing counsel, Your Honor. We met and conferred before trial. We also have a number of housekeeping matters, if we could briefly go through those.
Housekeeping matters?
Yes, Your Honor. Rule 615, constructive sidebars, things of that nature, as we haven't had the pleasure of appearing in your courtroom before.
I think we can run through those really quickly, but let's try to take this step by step so we can do this efficiently.
Absolutely.
Okay. In terms of any housekeeping, I'm not sure what housekeeping matters you have questions about.
Yes, Your Honor. Just to clarify, is Rule 615 to constructively sequester all witnesses in action right now, with the exception of course? Yes, Your Honor.
Witnesses will not be sequestered.
Yes, Your Honor. We'd ask for constructive sidebars for all objection arguments, since there's no way to approach the bench, just that they be constructively heard outside the presence of the jury.
On all objections?
All objections, Your Honor.
I'm not sure what the purpose of that is, counsel. Since it is my hope that counsel will not engage in speaking objections, if you simply state your legal objection for the record, the court will concisely state the ruling. That is not done. It's not necessary that that be done outside of the hearing of the jury, unless there is a unique, exceptional matter that needs to be taken up outside of the jury's hearing. So I'm going to reserve ruling on that and go on a case-by-case basis.
Understood, Your Honor. We understand that you've received an electronic notebook of all documents and exhibits. Is that correct?
Am I on the witness stand, counsel? Can we kind of cut to the chase here? What is there another issue that we need to address? And again, I'm really interested in getting to whether or not there is an evidentiary motion in limine that the plaintiff wishes to address.
Of course, Your Honor.
To give the defendant a chance to present a motion. But I don't know that either party wants to spend the entire trial on sort of micromanaging the housekeeping issues. You know, sometimes, counsel, it's okay to wait until there's an issue to address it.
Of course, Your Honor. One last one, then, Your Honor, we just asked to use Exhibit 1, which is stipulated to be authentic as a demonstrative in our opening statement.
I take it there will be no objection to that.
No objection, Your Honor.
Granted.
And then, Your Honor, just one substantive stipulation that we've come to with opposing counsel. There were 3 roommates at issue in this case, Your Honor. Defense pled a comparative fault affirmative defense against our client, Thomas Jordan, but did not name either of the 2 other roommates. And we just clarified that no argument regarding those 2 roommates' negligence will be made in court today.
So stipulated.
That's it from the plaintiff, Your Honor.
Okay. Does the defendant have a motion to eliminate they would like to address before the court?
Your Honor, defense also came to an agreement with opposing counsel on our motion. We also just wanted to put Your Honor on notice that we will too be using a demonstrative in our opening statement that was shown to opposing counsel in meet and confer. They shared no objection with us. If it's to the amenability of Your Honor that we use it.
No, so noted, and the court obviously has no objection. Demonstratives may be used during the opening statement. With that, I believe we are ready then to proceed with open. I'm sorry.
I'm sorry, Your Honor. I was unclear. That was just a housekeeping matter on defense's part that I wanted to get quickly out of the way for you. And we do have one substantive agreement with opposing counsel as well.
By way of eliminate, is this an eliminate matter that needs to be addressed in terms of an evidentiary issue the court needs to address prior to trial? I get it that you guys are pretty well into housekeeping, but the house is kept, and I would suggest we proceed to the substance of the trial. Is there a motion to eliminate?
Yes, Your Honor. We came to an agreement with opposing counsel that when they call their expert, Pat Murphy, to the stand, who has been friends with the defendant for several years and who has testified in their deposition that the defendant, Morgan Knight, took shortcuts in getting all of their work done at properties that were not 1414 Midvale, the one that was at issue in this case. And we agreed with plaintiff's counsel that that testimony will not be brought out as it's an admissible propensity evidence.
So noted and so stipulated. Now,
With that, we're ready to proceed to opening statements, Your Honor.
Thank you. All right, opening statements on behalf of the plaintiff, please.
Yes, Your Honor. May I proceed?
You may.
His life wasn't worth a look. It's June here in Steelton County, 2017. The defendant's CEO, a property manager named Morgan Knight, is taking 3 college students on a house tour. And even though this house is old, worn down, he makes it seem like the perfect home. Right by campus, plenty of space. It's even got a deck. But as the students walk across that deck, it creaks. Feels rickety. So one of them asks, "Hey, is this something you could get fixed?" Defendant says, "This deck? It's fine." Students shrug. They believe him. What they don't know is the defendant hasn't paid for an inspection to make sure that deck is fine. What they don't know is the deck feels rickety because it isn't safely attached to the house. What they don't know is that in less than 2 years, that deck is going to collapse. It's going to kill one of them. Thomas Jordan. The evidence will show the defendant never hired a professional to look at this deck to make sure it was safe. Because to this defendant, his life wasn't worth a look. That's why we brought a claim of wrongful death against the defendant, Knight Management Property, LLC. That means it's our job to prove, more likely than not, The defendant owed Mr. Jordan a duty of care. They breached that duty of care by failing to act reasonably, and that breach was a substantial factor in Mr. Jordan's death. We're going to meet that burden by showing you 3 simple facts. First, the deck was dangerous. Second, the defendant should have known that. Third, they never looked. So, starting with that first fact, the deck was dangerous. You're going to hear from an expert in building safety today, Mr. Patrick Murphy. He's the head of Steelton County's Residential Inspection Division, and he literally wrote the book on deck maintenance. This is the defendant's deck. Mr. Murphy inspected it the day after it collapsed, and I'll tell you what he found. It hadn't been properly attached to the house. He's going to testify that because of the way this deck was attached, it was a disaster waiting to happen. Members of the jury, you're going to learn that there is an industry standard way of attaching a deck to a house. You use something called lag screws, 1/2 inch around metal rods, which bind the deck to the house and are able to hold up all of its weight. But Mr. Murphy didn't find any lag screws connecting the defendant's deck to the house. Instead, what you'll learn is the defendant's deck. It was held up only by nails. The evidence will show that's dangerous. In this case, deadly. Fact number 2. The defendant should have known that. After the defendant's deck collapsed, we deposed their CEO. We asked him, why didn't you fix the deck? He said it's because he didn't know it was broken. But the evidence will show he should have known. That the county told the defendant they needed to get their deck inspected every year. Members of the jury, the county inspector himself will tell you, most decks, they last 15 years, 25 if you're lucky. But this deck was over 30 years old. And it showed. You'll hear from both of the students who lived at that house with Mr. Jordan. This deck felt unstable from the day they moved in. It was rickety, it creaked. One day they even felt it shift. So they texted their landlord, they texted the defendant, hey, can someone come take a look at this? For safety reasons. Fact number 3. The defendant never looked. It will be undisputed that when the defendant learned this deck was over 30 years old, they didn't pay for an inspection. Undisputed that when this defendant learned decks need to be inspected every year and this one had been inspected in 3, they didn't pay for an inspection. Undisputed that when their tenants texted them saying, for our safety, please inspect the deck, they still didn't pay for an inspection. You'll learn why. The evidence will show the defendant has a policy. They never pay for safety inspections. After Mr. Jordan died, the defendant said this was his fault. You see, Mr. Jordan was having a party that day. People were using the deck. But what you'll hear is that the defendant never told these tenants there was a weight limit. never told them this was a 30-year-old deck, never told them it hadn't been inspected in over 3 years. The evidence will show this defendant said exactly 2 words to those students about this deck. It's fine. You'll hear that on that first day, when their property manager was giving them a tour, that deck was already breaking because it wasn't attached properly. And the question today will be, who's responsible for that? The students who thought their new home was safe, or the landlord who told them it was without ever making sure? At the end of this trial, we're going to ask that you find Knight Management liable. Because to the defendant, his life wasn't worth a look. Thank you.
Ms. Marr, is the defendant ready to proceed with their opening statement?
Yes, Your Honor.
You may proceed.
Morgan Knight did not cause the death of Thomas Jordan. When a life is lost, it's understandable to look for someone to blame, but Morgan is not that person. You'll hear the truth about Morgan Knight is simple. Each time the tenants at 1414 Midvale told Morgan they had an issue, Morgan took care of it immediately. But for almost 2 years, no one told Morgan about an issue with or a concern about the deck. Morgan started taking care of this property back in 2017 when a local businessman named Mickey Terranova bought the house and hired Morgan's company to manage it as a rental. Morgan's company is Knight Property Management, and he runs it himself right here in Steelton. Before the sale at 1414 Midvale was final, Morgan did a walkthrough of the house. Now, plaintiff told you in their opening that Morgan never looked, but you'll hear that during this initial walkthrough, he checked the deck himself and later reviewed a professional inspection report, which had just been done the year before. A report that told him there was no deterioration, no damage, and everything was properly installed. And only after that did Morgan rent the house out to 3 college students with a lease that made everyone's responsibilities clear. Tenants, keep the place in good condition. Landlord, if there's a repair needed, do it. And that's how it worked. The 3 housemates designated one of them, Alex Rios, as the point person between them and their landlord, Morgan. And Alex, one of Thomas's best friends, will tell you that anytime he called or texted, Morgan responded immediately. The only time that Morgan was ever informed about a problem with the deck was on April 30th of 2019, just 11 days before the accident happened. After 2 years of living at the house and using the deck, the tenants texted Morgan to tell him the deck was making creaking noises. And based on that text, Morgan acted. That's why there won't be proof of negligence today, a word that means Morgan acted unreasonably. The plaintiff won't be able to show you that because despite
telling you in their opening that Morgan never hired a professional to look at the deck, you'll hear that Morgan reached out and scheduled a deck inspection right after he got this text. There's another reason you'll know that the plaintiff can't prove their case. They can't prove what caused the deck to fall. You'll learn their own deck inspector never spoke to a single person who was there when it fell. Never saw this deck or its attachment to the house before while the deck was still standing. Never performed any tests to see if the deck could hold the number of people on it all at the same time at that graduation party. Never did any research to see what the weight limits might have been. You'll learn that all their inspector did was take one look at the deck, one picture, and make up their mind. Now, I need to talk to you about some of the choices that Mr. Jordan made. Choices that Morgan was never made aware of, and one choice in particular that plaintiff didn't really tell you about in their opening. Let's look at a timeline of some of these choices. You'll hear that just 5 months before the deck collapsed, Thomas and his roommate Taylor had a Christmas party at their house. Party where about 10 of them were hanging out on the deck when all of a sudden it moves under their feet. But after this happens, they just keep using it. And the next morning, no one chooses to call Morgan to tell him what happened so that he could get it checked out. They waited 4 months to text Morgan and tell him that they wanted an inspection. But when they sent that text, you'll see the only thing they said was that it was making creaking noises, not that it had moved. And based on that, Morgan tells him, I'll look into it. And he gets an inspection scheduled. But before that inspection could happen, and without asking or notifying Morgan about what they would be doing, the tenants threw a massive house party with upwards of 50 to 100 people, where at one point they invite every single one of those people out onto the deck that had just moved 5 months before. And sadly, that's the moment Mr. Jordan decides to go under that deck while the weight of all those people loomed above him. Members of the jury, you'll realize throughout this case that Mr. Jordan's choices cannot be called ordinary care. They're actually something called comparative negligence. And we'll explain what that means is that Mr. Jordan's choices contributed to his own death. Were this case about whether his death was a tragedy, we wouldn't need a trial. It was, and no one would ever say otherwise. But in this trial, you're being asked to blame one person and one person alone. And our justice system does not place blame without first examining all the facts. And when you do that, you'll learn Morgan Knight was a landlord who responded promptly, who did not refuse to pay for repairs or inspections, who did what the law required, used ordinary and reasonable care. And that's when At the end, my co-counsel, Mr. Heyman, will come back and ask you to return the only verdict that the law and the facts will support. Knight Property Management is not responsible. Thank you, Your Honor.
Okay, would the plaintiff please call his first witness?
Yes, Your Honor. The plaintiff calls Taylor Williams.
Ms. Williams, please step forward and raise your right hand. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. Thank you. And you may proceed, Ms. Stebbins.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself for the jury?
Good afternoon. My name is Taylor Williams.
What do you do for a living, Miss Williams?
Well, I'd always dreamed of being a soccer player, but after I was injured, I took a corporate job. So that's what I do now.
Where do you live?
I live here in Steelton.
How long have you lived here in Steelton, ma'am?
Well, I graduated college in 2019, and I lived here all throughout college. So it's been several years now.
Miss Williams, did you know Thomas Jordan?
Yes, he was my best friend.
You said he was your best friend. How often did you see him in May of 2019?
In May, I saw him pretty much every day. We were roommates, so I would see him all the time.
Did you live with anyone else?
Yes, there was 3 of us, myself, Tommy, and our friend Alex Rios.
Where did you live?
We lived in a house near campus on 1414 Midvale Ave.
How long did you live there, ma'am?
We moved in June of 2017 until May of 2019, so almost 2 years.
When was the last time that you saw Mr. Jordan?
The last time was on May 11th, 2019. I was there when he died at our house.
Miss Williams, can you turn to Exhibit 1 in your notebook and let me know once you're there?
Sure, I'm here.
What's Exhibit 1?
This is a photo of our deck after it collapsed.
Does it accurately depict how the deck looked after it collapsed?
Yes, it does.
Plaintiff offers Exhibit 1.
Any objections?
No objections, Your Honor.
Exhibit 1 is admitted.
May we publish via screen share, Your Honor?
You may.
Miss Williams, you said Thomas Jordan died at your house. How did he die?
Well, he was underneath this deck when it collapsed on top of him.
Who did you rent this house from?
We rented it out from a person named Mickey Terranova, but our property manager was someone named Morgan Knight. Yeah, so we worked primarily with her.
Thank you, Mr. Wax. We can take that down. Let's talk about who was responsible for that deck, ma'am. Do you see Exhibit 6 in your notebook?
Yes, I do.
What is it?
This is the lease that we signed with Morgan Knight.
Is it a fair and accurate copy of that lease?
Yes, it is.
You said you signed it with Morgan Knight. Could you tell us who all signed this document?
Sure, I signed it. My other roommate, Tommy, signed it, and our other roommate, Alex, signed it also.
You said it was with Morgan Knight. Did he sign it as well?
Yes, he also signed it.
Plaintiff offers Exhibit 6.
Any objections?
No objections, Your Honor.
Exhibit 6 is admitted.
May we publish via screen share?
Sure, you may publish it.
Ms. Williams, I want to talk through several portions of this lease. According to this document, whose responsibility was it for completing repairs and maintenance?
It was Morgan Knight's.
Did you ever speak to Mr. Knight about repairing your deck?
Yes, we did. We actually talked to Morgan about it twice.
We're going to come back to that lease in just a minute, but first I want to take those one at a time. When was the first time you asked Mr. Knight about the deck?
The first time we asked Mr. Knight was during our initial walkthrough of the house before we even moved in.
What happened during your initial walk?
Well, I noticed that the deck looked a little bit old. I didn't know how sturdy it was, so Thomas just asked Morgan if he would be willing to repair it for us.
You said Thomas Jordan asked Morgan Knight if he'd be willing to repair the deck. How did Mr. Knight respond?
He said it was fine.
Did he tell you how he knew that it was fine?
No, he didn't explain further.
After you moved in, did you ever stand on the deck?
Yeah, we would regularly stand out on the deck, have people over, have meals out there, hang out there with our friends.
You said the deck was creaking during your walkthrough. How often did it creak after you moved in?
It creaked all the time.
Let's talk about the second time you asked the defendant for maintenance on that deck. What happened?
So the second time, it was after a Christmas party we had at our house in December of 2018. We were all standing out on the deck, and all of a sudden we just felt kind of a noticeable shift. It wasn't a huge shift, but it was definitely noticeable. And then we all started talking about it.
Had that creaking you mentioned earlier stopped by this point?
No, not at all.
So what did you do?
Well, I talked with my roommates about the deck, and Alex said that he was going to text Morgan and ask him if he could schedule a deck inspection.
I want to go back to your lease for a moment. Your Honor, may we republish Exhibit 6?
You may.
Ms. Williams, you told us about the conversations you had with Morgan Knight about your deck. Did he actually have access to your deck to repair it?
Yes, like you can see here in the lease, Morgan had access to our backyard at all times.
If a problem had been discovered, whose responsibility was it to pay for the repairs?
It was Morgan Knight's.
In the 2 years you lived there, are you aware of Mr. Knight ever repairing your deck?
No, I'm not aware.
In the 2 years you lived there, are you aware of anyone ever showing up to inspect your deck?
No, I'm not aware of any inspectors.
In the 2 years you lived there, are you aware of Morgan Knight ever even accessing your deck to follow up on your concerns?
No, I'm not aware of that.
Do you know of them sending anyone else to follow up?
No.
In the 2 years you lived there, are you aware of Mr. Knight ever hiring anyone to come fix the deck?
No, I'm not.
Thank you, Mr. Wax. And Ms. Williams, now that we've talked about the state of your deck, I need to ask you about what happened on May 11th, 2019. What were you doing that day?
Well, on that day, we were having a big party, so I was pretty excited. We invited some friends over to our house to celebrate our graduation.
I want to be upfront with the jury, ma'am. You said you were having a party. Were you drinking that day?
I was. It was a college party.
How much did you have to drink?
I had a few beers and a few tequila shots.
How many people were there?
I don't really know the exact number. People were kind of coming and going all throughout the day.
And Ms. Williams, where were you when the deck actually collapsed?
I was on the deck. Thomas and I had both been standing on the deck, and I asked everyone to come out on the deck to take a group photo.
Was Thomas Jordan still on the deck with you?
No, actually, Thomas dropped his phone over the side of the deck, and I offered to take the photo with my own phone, but Thomas was really insistent on taking it with his phone, so he went underneath the deck to go get his phone.
How many people were on the deck?
I don't know specifically. There was a bunch of people on the deck.
What happened next?
I don't really know. The last thing that I remember is hearing a loud cracking sound and Thomas screaming and the deck collapsing. And the next thing I remember is waking up and I was in a hospital.
What happened to Thomas?
Thomas died. He was crushed instantly under the deck.
Thank you, Ms. Williams. No further questions, Your Honor.
Excuse me, your witness, Ms. Mara.
Yes, Your Honor. Hi, Ms. Williams.
Hi.
This house was one where you lived for 2 years, right?
Yes, that's correct.
And once you moved in, you started having parties at the house.
Yeah, we did.
And over those 2 years you lived there, there were a lot of parties.
Yeah, we partied pretty often.
And at those parties, people would go out on the deck.
Yes.
And in 2017, after those parties started, no one complained to Morgan about the deck.
Objection, Your Honor. Speculation, or calls for speculation, excuse me.
Overruled. You may answer, Ms. Williams.
No, not after those parties.
And no one complained to Morgan for the entirety of 2018 either.
No, not in 2018.
I want to talk to you about that party in December. You and Thomas had a Christmas party, right?
Yeah, we had just finished our finals and we were celebrating Christmas.
And that was a party where you were all out on the deck,
Yep, we were on the deck.
including Thomas,
Yes, including Thomas.
with about 10 of you total.
Yes, I think there was around 10 of us.
And the deck, it moved.
Yeah, there was a noticeable shift.
Well, it moved like it was coming loose, didn't it?
Yeah,
Moved to the point where Thomas said, "Whoa, did you all feel that deck move?"
yeah, Thomas said that.
But Thomas didn't then say, "Everyone, party's over."
No,
And you didn't then say, "Everybody off the deck."
I didn't say that, no.
Everybody just kept partying.
Yeah,
And the next morning, no one called Morgan, did they?
no,
To tell him that the deck had moved
no, not the next morning.
or that it was rickety
No,
or that it felt unstable.
no, we didn't say that the next morning.
Well, to be clear, Ms. Williams, you didn't say any of that to Morgan ever, did you?
I didn't tell Morgan Knight that personally, no.
Because Alex was the point person that you had all chosen to communicate with Morgan for the group.
Yes, Alex usually spoke on our behalf.
But Alex, he wasn't at this party.
No, he wasn't at that party. We talked to him about it though.
He was home for winter break, right?
Yes,
You didn't call Alex the morning after it happened either, did you?
no, not the morning after.
You waited until he came back for school.
Yes,
And after you let him know, you never followed up to see if he had called Morgan.
no. I know that he texted Morgan though.
Well, I'll get to that, Ms. Williams, but before he texted Morgan and after the deck moved, you all kept using the deck, right?
Yes,
Now, you said that you didn't tell Morgan about any repairs or anything about the deck until after the Christmas party, but I just want to clarify, that was 4 months after the Christmas party, right?
yes,
In April of 2019.
yes, that's when Alex texted her.
You saw on social media that it was Building Safety Month.
Yeah, I did.
You had thought the deck should be inspected,
Definitely.
but you never saw an inspector come.
No,
And then on May 11th, you all had a party.
yeah,
There were easily 50 people at your house over the course of that party, right?
Yes, over the course of 6 hours.
You and Thomas wanted a group photo with all your friends.
Yeah, we did. We were celebrating our graduation.
So they were all invited to come outside
Yes.
onto the deck.
Yes, I told everyone to come take a group photo.
And people started coming out.
Yes.
Thomas takes out his phone for the photo.
Yes, he took out his phone.
While people are still coming out, he drops it
Yes, he dropped his phone over this side of the railing.
and it went under the deck, right?
Right.
You tell him, we can just use mine.
Yeah, I did. He was really insistent on getting a photo with his own phone.
Right, so he ignores you.
I think he just wanted to take a photo with his own phone.
Well, to be clear, Ms. Williams, you told him that he didn't have to get his, right?
Yeah.
And he went down the stairs to get it anyway.
Yeah, he wanted to take the photo with his phone.
A bunch of people on the deck are leaning against its railing, right?
I think some people were leaning against the railings, yes.
And that's when Thomas goes underneath.
Yes.
No further questions.
Can you redirect?
Yes, Your Honor. May I proceed?
You may.
And Ms. Williams, opposing counsel just asked you about having a lot of people out onto the deck. Did Morgan Knight ever tell you there was a maximum capacity or number of people that could safely be out there?
No, Morgan never said anything about a maximum capacity.
But did Mr. Knight ever tell you anything about a weight limit that could safely be on the deck?
He never said anything about a weight limit either.
Thank you, Ms. Williams. No further questions, Your Honor. May the witness step down?
The witness may step down. Thank you, Ms. Williams. Counsel, would you like to call your next witness?
Yes, Your Honor. The plaintiff calls Mr. Patrick Murphy.
Okay. Good afternoon, Mr. Murphy. Could you please raise your
Good
right hand?
afternoon.
Could you please raise your right hand, sir? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. You can put your hand down. Mr. Wax, you may proceed.
Thank you, Your Honor. Good afternoon. Would you please introduce yourself to the members of the jury?
Good afternoon. My name is Patrick Murphy.
What do you do for a living?
I'm the director of the Steelton County Permitting Services and Residential Inspection Division.
How are you involved in this case, Mr. Murphy?
I was asked to inspect a deck that had collapsed at 1414 Midvale.
What does the Permitting Services and Residential Inspection Division actually do?
It's pretty simple. We make sure people's homes are safe. We find and fix problems. We publish safety guides, and we perform inspections of buildings.
How long have you worked at that division?
Over about 3 decades now, 12 as an inspector and almost 20 as a director.
Do you have any degrees or certifications?
Of course, I have a degree in engineering from Steelton University that I got back in 1988, and I got my building official certification right afterwards.
You told us that in this case, you were asked to inspect a deck. Do you have any experience with decks in particular?
Oh, yes, I do. I've built them, I've inspected them. I put out the county guidelines on deck maintenance.
Mr. Murphy, have you ever worked as an expert in a case before?
Yes, I've been an expert in 20 cases now.
Have you ever testified as an expert, sir?
Yes, in 3 of those disputes, the matter actually went to trial, and I testified as an expert in all 3 of those.
And just to be clear, are you being paid by either of the parties here today?
No, I wasn't. I'm not being paid by either side. I'm only employed by the county. I was asked to talk to you good people about what I saw and what I did.
Your Honor, at this time, plaintiff proffers Mr. Patrick Murphy as an expert in building safety specifically deck maintenance.
Any objections?
A brief voir dire, Your Honor, if that's allowable.
Of this witness,
Yes, Your Honor.
you may proceed.
Good evening, Mr. Murphy.
Good afternoon.
Mr. Murphy, you've never investigated deck collapses before, have you?
Other than the one for this case, no, you're right.
You've never tested the
Excuse
strength
me,
of
hold on for 1 second, counsel, I'm sorry. What's the purpose of your voir dire here? It sounds like, I mean, you're going to have an opportunity, I presume, to cross-examine this witness. I don't think this is the proper time. Is there a specific reason that you feel like you need to voir dire this witness regarding his qualifications to render expert opinions? If you have an objection, just state your objection and let the court rule. But I don't know that you need to get into cross-examining this witness twice.
Your Honor, simply to test qualifications for giving an opinion in this case. They're going to testify on opinion on causation, Your Honor. We just want to probe their qualifications on this voir dire. If Your Honor would like me to wait for cross, I can do that as well.
If you have a specific objection, I believe you know what this witness's background is. If you have a specific objection, the court will hear it and is willing to take it up prior to making a determination whether this witness may offer this expert testimony. If
Yes.
not, you may certainly cross-examine this witness. So,
Yes, Your Honor. Then at this time, oh, I apologize.
I'm not hearing a basis for voir dire. Do you have any objections to the proffer of this witness as an expert witness in this case?
Yes, Your Honor. May we be seen
What is your objection?
Your Honor, we're not objecting to this witness testifying as to deck safety or deck construction or building maintenance, but specifically on the sole issue of what caused this collapse. In their deposition, they claim that this deck probably collapsed because it was attached with nails. However, other than this case, they've never investigated a deck collapse, Your Honor, and they've never tested.
Counsel, I think perhaps you should address that with him on cross-examination.
Yes, Your Honor.
That goes to the credibility and weight to be afforded his testimony, not to his qualifications to give those opinions. The objection is overruled, and this witness qualifies to render the expert testimony and the expert opinions in this case, subject to cross-examination, of course. Mr. Wax, you may proceed.
Thank you, John. Mr. Murphy, did you know either of the two parties before their deck collapsed?
Yes, I know Mr. Knight well.
How do you know the defendant's CEO?
We've been friends for years. We're on the same bowling team.
Mr. Murphy, you're aware that I'm going to have to ask you some questions about your friend. Is that all right?
Yes, I mean, it's part of the job.
Let's talk about the defendant's deck. What information or materials did you have in coming to your conclusions?
I inspected the site of the collapse the day after it happened. I also had access to almost every document in this case, including Morgan Knight's deposition.
What principles and methods did you use to inspect this deck?
Well, I examined the collapsed deck, especially the way it appeared to have been attached to the house. I compared this to industry standards for a deck like that.
Did you apply those methods reliably?
Yes.
Were you able to form any conclusions?
I was, yes.
And were you able to form those conclusions to a reasonable degree of certainty in your field?
Yes, I was.
What did you conclude, sir?
The way this deck was constructed made it a disaster waiting to happen. And looking at the deck would have revealed that.
All right, Mr. Murphy, let's take those conclusions one at a time, starting with your first one. What was it about how this deck was constructed and made it a disaster waiting to happen?
The fasteners.
What's a fastener?
It's a material that's used to connect the side of the deck to the side of a house.
I want to give the members of the jury an idea of what that generally looks like. Your Honor, permission to republish what's already in evidence as Exhibit 1.
You may.
Mr. Murphy, do you recognize this photograph?
I do. This is the collapsed deck that I inspected at 1414 Midvale.
Sir, where would fasteners go in a deck?
They would go through the ledger board. That's the piece of wood that sits under the deck and attaches it to the house.
Why is it that fasteners affect whether or not you're going to have a disaster?
Well, you see, a deck, it has to hold up a lot of weight. People, furniture, barbecue grills, you name it. All of that puts a lot of weight on the deck. You need fasteners that have the shear strength for that job.
Thank you, Ms. Evans. We can take that down. Sir, could you tell us where exactly a fastener is used in the deck, where it goes?
Certainly. So you have the side of the house and you have your ledger board. The fastener goes through the ledger board and into the house to fasten or connect them together.
What type of fastener are we using here?
The fastener you're supposed to use is a 1/2 inch diameter lag screw.
What's a lag screw?
It's a very strong, very thick screw.
Mr. Murphy, can you use something besides a lag screw?
You could use a 1/2 inch steel bolt, but other than that, you're not supposed to.
Well, how common is it to use 1/2 inch diameter lag screws or bolts in decks that are safely constructed?
It's not a question of how common those two fasteners are. It's what should always be used. And lag screws or thick bolts, those should always be used when you're constructing a deck.
Mr. Murphy, you said that you inspected the property in this case. What material did you find the defendant's deck was attached to the house with?
Nails.
Sir, under what circumstances would you use nails to attach a deck to a house?
Never. You should never use nails to attach a deck to a house.
Why is that?
Nails are just too weak. It's a disaster waiting to happen.
So let's talk about your second conclusion, that an inspection that you would have been able to see those nails. So is there a standard procedure for a typical deck inspection?
Yes, there is.
What is that standard procedure?
Well, on the deck, you'd use a screwdriver to scrape away at the wood and verify it's still strong. Under the deck, you want to count the number of fasteners and check those fasteners. You want to tighten all the nuts and bolts and check for rotting wood. Those are really the main steps.
How often should a deck be inspected?
At least once a year. And that's for all decks, even ones that aren't past their prime.
What do you mean by a deck that's past its prime?
Decks tend to only last 15 to 25 years.
Mr. Murphy, according to the defendant's CEO's deposition, how old was the deck in this case when it collapsed?
32 years old.
You said that deck should be inspected every year. According to the defendant's CEO's deposition, how many years had it been since this deck was last inspected by a professional?
According to what I reviewed in Morgan Knight's deposition, the property had not been inspected since 2016.
Is that 3 years then?
2016 to 2019 is 3 years, yes.
Mr. Murphy, was there any way for the defendant to know that decks are unsafe after 25 years?
Yes, I gave him guidelines that said that.
When?
2017.
Was there any way for the defendant to know that decks need to be inspected every year?
Yes, I gave him guidelines that say that too.
When?
Also in 2017.
So going back to your conclusion that looking at this deck would have revealed the problem with the nails. So how do you know that?
Excuse me, counsel, I'm sorry.
Yes, sir.
I was disconnected.
Of course.
I believe after counsel had asked, when was the last time the deck had been inspected, or was there a question along those lines?
Yes, Your Honor.
Okay.
Would you like me to repeat that testimony since we don't have a court reporter? Mr. Hammond, can we agree that we're stopping time for this?
Counsel,
Yes, Mr. Wax.
Sorry, Your Honor, I believe that you cut out again.
did, and I'm apologizing. Hold on for 1 second. Let me. Okay. Again, my apologies, counsel. The truth of the matter is, there's only so much we can do to control broadband. So we'll persevere through this. Go ahead, counsel.
Not a problem at all. Your Honor, would you like me to go back to the last question I said before you disconnected?
Please.
Mr. Murphy, you said that decks should be inspected at least once a year. And according to the defendant's CEO's deposition, when was this deck last inspected before it collapsed?
According to Morgan Knight's deposition, the last inspection was in 2016.
How many years before the collapse was that, sir?
2016 to 2019 is 3 years.
Was there any way the defendant could have learned that decks are typically unsafe after 25 years?
Yes, I gave him guidelines that said that.
When?
2017.
Was there any way for the defendant to know that decks need to be inspected every year?
Yes, I gave him guidelines that said that.
When?
2017.
So going back to your conclusion, how do you know that just looking at this deck would have revealed the problem with the fasteners?
Because I did an inspection the day after the collapse, and I saw the nails.
Did you need any special tools to do that, sir?
No, I just looked at the base of the deck.
Do you know if those nails were visible before the collapse?
They were. One of the students who lived at the property stated they saw the nails connecting the deck to the house.
So when you looked at this ledger board, how many nails did you see?
There were hundreds of them.
Thank you. No further questions at this time.
Mr. Heyman, you may inquire.
Mr. Murphy, good afternoon.
Hello again, sir.
Well, now, Mr. Murphy, you've never investigated a deck collapse before, right?
That's right. This is the first time I'd investigated a deck that collapsed.
You've never tested the strength of a deck that's held up by bolts, right?
That's correct.
Or screws?
That's correct. You're right. I
Nails.
didn't do any tests. Yes.
You've never tested the weight limit on decks of any size?
That's right. Yes.
The last time that you built a deck, that was 1983, right?
Yes, that sounds right. Back in my construction days.
Mr. Murphy, I want to talk about the inspections that your office was doing in spring of 2019. That was part of Building Safety Month, right?
Yes, it was Building Safety Month. Free deck inspections for any property in Steelton with a deck.
And Morgan Knight asked you about getting one of those done at 1414 Midvale.
Yes. Morgan wanted inspections for all the properties with decks.
You scheduled one for that property on May 20th.
Yes.
That was the earliest date that you could squeeze him in.
That was the date that was scheduled. Yes.
Now, since we're talking about these inspections, I want to ask, you would agree that a good inspection, it would look for things like unsuitable installation?
Yes, an inspection would generally look at the installation to make sure that's proper.
It would look for damage.
Yes, a proper inspection would look for damage to the deck.
It would look at deterioration, right?
Absolutely.
Now, at those 2019 inspections, you were giving away your guidelines.
Yes, the guidelines, I put those on social media and I gave them out with every inspection.
Now, to be clear, that is your guide, right?
Yes, that's the list of guidelines that my office gives out.
You said on direct that these were county guidelines, but they're not in the county code, are they?
Oh, that's right. They're just something that our office gives out to homeowners with decks or as part of our inspections.
They don't have a big old county government stamp on them, do they?
Oh, no, that's right. They're something our office gives out for best practices in deck maintenance.
The guide, it's not the law.
Not that I'm aware. I'm not aware of my guidelines ever being codified.
Your goal for those guidelines was to help the average homeowner get a basic idea of how to maintain a deck.
Absolutely, yes.
Like what to look for, what to do when it came to decks.
Exactly, how to make sure that the decks are safe and that they get the most use out.
Now, today, you have talked about the importance of using screws or bolts to attach a deck, right?
That's right, in the construction of a deck.
I went through your guide. Your guide does not say, look for lag screws in the ledger board, does it?
That's right, that isn't in there.
It doesn't say, look for bolts in the ledger board.
No, it says to make sure any bolts are tightened, but it doesn't specify that those should be installed in the ledger board. You're right.
It doesn't say to make sure there are no nails in the ledger board.
That's right.
It does not say to replace nails if you see them with screws or bolts.
That's right.
I want to talk about what you did at 1414 Midvale.
Certainly.
This was the first time you had ever seen the deck, right?
That's right. The day after the collapse was the first inspection I had done of that property.
And your entire investigation on May 12th, it was just that one visit, right?
That's right. I got to the property and I examined the construction of the deck that had collapsed.
You had no tools on you.
That's correct.
You had a camera though, right?
Yes.
And with that camera, you took one picture.
Yes.
Mr. Murphy, poor attachment, it's not the only thing that can cause a deck to fall, right?
Oh, you're right. Yes, there could be improper attachment or wood rot. Those are the two big ones we definitely see most often.
Another cause besides wood rot, it could be extreme pressure from too much weight, right?
Oh, certainly. If you overload the deck, that could be a problem.
As the primary investigator, I'm sure it was important for you to make sure that your conclusions were reliable, right?
Yes.
One way to do that is to look at the other possible causes and make sure they weren't at issue.
That's correct. Yes.
In this investigation, you talked about looking at the ledger board, right?
Yes. I investigated the ledger attachment section.
But I am sure that you also looked for wood rot.
I did not note any wood rot.
Is it your testimony that you did look for wood rot, Mr. Murphy?
No, it's my testimony that I didn't see any wood rot. That wasn't something I saw.
I am sure that you interviewed people who were at that party when the deck collapsed, right?
No, I did not. No, I was focused mainly on the construction of the deck.
You didn't find out if people were taking photos at that party, did you?
No, I didn't read about the photo situation until after I'd done my investigation. That I learned about that through the depositions.
Oh, Mr. Murphy, you did not ask anyone if they had photos that showed how many people were on the deck, right?
No. I didn't talk to anybody. I just looked at the deck.
Photos that could have shown where people were standing on the deck.
Right. I don't know about any other pictures.
On May 12th, You had no idea how many people were on that deck when it fell, right?
That's correct. I didn't know. I was looking at the construction for construction defects.
You also didn't talk to the firemen who called you to see if the deck had been moved since the collapse, did you?
I didn't discuss what the firemen did.
You didn't find out if the deck had been repositioned at all.
Well, I'm not sure how they got that poor young man out from under the deck, but I didn't talk to them to see what they did.
So you don't know if that deck was repositioned, Mr. Murphy.
I couldn't tell you. I wasn't there in the aftermath.
On direct, you talked about the average lifespan of the deck, right?
Yes.
But you would agree that if a deck is properly maintained, that lifespan, it can be extended.
Yes, a properly maintained deck is generally going to last longer than one that is improperly maintained.
When you went to the scene on May 12th to inspect the collapse, you had no knowledge of how the deck at 1414 Midvale had been maintained.
Yes, this was the first time I'd ever been called out to that scene to inspect this deck or even talked about this deck.
Let's talk about the picture you took.
Of course.
That picture, it doesn't show the ledger board.
That's correct. That's a general picture of the scene that like it was when I got there.
It doesn't show what the problem was with any of the original screws in the deck, does it?
No, it does not.
You can't tell us what that problem was, can you?
No, I don't know what the problem was.
That picture does not show any nails.
You're right. You can't see nails in that picture.
But on direct, you said that you saw nails, right?
Yes, hundreds of nails in the ledger board.
But you don't know when those nails were installed, Mr. Murphy, do you?
That's right.
They could have been in there for 20 years.
That's certainly possible. I don't know when they were installed.
Or 40 years.
No.
Or 30 years. How about that, Mr. Murphy? I apologize.
Right, because the deck was 32 years old, so could have been as many as 32.
It has been 3 years since the collapse, correct?
Yes, it has now been about 3 years.
Plaintiff's lawyers, they knew you were an engineer.
Yes, I have an engineering degree.
No one asked you to do further testing, correct?
No. I just did what I did my investigation, and now I'm here to tell you what I saw.
No one asked you to test a ledger board that was fastened like this one, did they?
That's correct.
To conduct any research.
That's right. I just told you what I saw at the scene of the collapse.
To do anything at all beyond walking the scene, reading some depositions, and taking a picture.
I also examined the ledger board and did things at the scene of the collapse.
Nothing further, Your Honor.
Any redirect examination, Mr. Wax?
Yes, Your Honor. Mr. Murphy, you were just asked about some maintenance guidelines for homeowners based on the industry standards in your field. What's safer, all else being equal? A deck constructed using nails as an attachment or a deck with lag screws?
A deck with lag screws is safer.
No further questions.
Thank you, Mr. Murphy. You are excused.
Thank you, Your Honor.
Mr.
And with
Wax,
that,
I'm sorry, go ahead.
my apologies as well, Your Honor. With that, the plaintiff rests.
Okay. And with that, I think we're going to take a brief break before we begin the defendant's case. How about 5 minutes? So we will, my clock says it's 5:12 Central Time. So we will reconvene at 5:17 Central Time.
Yes, Your Honor.
Yes, Your Honor.
If the judges could briefly join me back in the judges breakout room when you're back to your computer, that would be great.
Sorry, Jen, who?
If the judges could go back to the judges breakout just for 2 minutes when you're all back.
Okay, I will.
Thank you. You should be able to rejoin on your own.
Okay.
Yeah, how do we get there, Jennifer?
Let me see if I have to add you back again. I might need to. So I'm going to put you instead in the coaches room just for 1 second. So you should get another little.
Okay.
Okay, it looks like we have all counsel and all jurors are back in the box. We're ready to proceed. The defense may call its first witness.
Yes, Your Honor. The defense calls Morgan Knight to the stand.
Mr. Knight, would you please raise your right hand? Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, you may put your hand down. Counsel, you may proceed.
Mr. Knight, you've been accused of failing to inspect and then failing to check that deck. Is that true?
No, that's not true.
When it comes to inspections and checking that deck, what did you do, if anything?
I did a visual inspection of that deck. I walked the deck myself, and I actually looked under it as well before anybody ever moved into that house.
We're going to get back to talking about 1414 Midvale, but first I want to ask you, can you tell the jury what Knight Property Management is?
Yes, I can. It's my business right here in Steelton.
And how long have you been operating that business?
Been doing it for 26 years.
You know that this case is about the deck at 1414 Midvale. In the 2 years that Thomas Jordan, Alex Rios, and Taylor Williams were your tenants, what would you do whenever they requested a repair?
I responded.
And you heard that, I apologize. And in those 2 years, when was the first time you got any requests about the deck?
Just 11 days before this horrible accident at the end of April of 2019.
Sir, who was the actual owner of 1414 Midvale?
It was Mickey Terranova.
If Mickey was the owner and you were the property manager, what were your responsibilities in that relationship?
So I would prepare the house to get rented. I'd collect the rent, handle maintenance and repair requests as they came in.
Was there ever any pressure from Mickey to cut costs or not to do repairs?
No, Mickey never even questioned me about bills or repairs. He just trusted me to get things done.
Mr. Knight, when was the first time you saw 1414 Midvale on the deck?
I actually went with Mickey to tour the house before he bought it. We looked at the deck at that tour.
And when was that tour?
That was at the end of April 2017.
When you did that tour back in April of 2017, did you check the deck at that time?
I did. I walked the stairs, checked the railings. I even looked underneath before we rented it out. I saw nothing out of the ordinary. I also got the inspection report from the previous year.
Your Honor, I'm directing the witness to what has been previously marked as Exhibit 10 on page 69 of the electronic file. Mr. Knight, do you have a copy in front of you?
Yes, I do.
Can you please tell the jury what this is?
So this is that inspection report that I asked for before Mickey purchased 1414 Midvale.
Is this a fair and accurate representation of the inspection report?
It is.
Your Honor, I request that Exhibit 10 be moved into evidence.
Objection to hearsay, Your Honor. May we approach?
Yes, you may. And we do need to take this up outside the hearing of the jury.
Doing that constructively, Your Honor.
Okay.
Your Honor, we don't have an issue with this being entered for notice, but we would ask for a limiting instruction that it should not be taken for the truth of the matter asserted within this document.
I believe that's appropriate. All right. The jurors are instructed as to, well, first of all, what's the exhibit number again? I'm sorry.
10, Your Honor.
All right. Exhibit 10 is admitted. However, the jury is instructed that it is admitted for purposes of examining what notice, if any, the defendant had of any issues. You may not consider it for the truth of any specific matter that is asserted in the report itself.
May I proceed, Your Honor?
You may.
May we publish?
You may.
Mr. Knight, can you please tell the jury the date of this report?
Yes, this report was signed on March 1st, 2016.
And did this form contain an explanation for how it might be filled out by an inspector?
It did. It said if something was inspected and passed, the I box would be checked. And if something was inspected and it was deficient, the D box would be checked.
Mr. Knight, you were in the room when Pat Murphy said that a good inspection, it would look for damage, deterioration, unsuitable installation. I apologize. Is that correct?
That's correct. I was here.
What types of issues, if any, did the 2016 inspection report look for?
So to determine if something was deficient and to check that deficient box, the inspector looked at whether there was any damage, deterioration, or unsuitable installation.
On this inspection form, was deck specifically listed?
Yes, it was.
Can you tell us what it says about the deck?
It says that the deck was inspected and that it passed inspection.
Does this report have any cautions?
It does. It says a few things. It says that things might have changed and a person might want to hire their own inspector.
And even after reading that, were you still comfortable relying on this report?
I was, because I'd also seen the deck and been out on the deck myself.
The jury has heard that the tenants took possession of this house in spring of 2017. If repairs were needed, how would that work?
The tenants would reach out to me and I would get the repairs done.
Did that happen often?
Not too often, just a few times.
And we've already seen the lease today. Can you tell us what were the responsibilities of the tenants in that lease?
The tenants were supposed to keep the property clean and in good repair.
And what were yours within the lease?
To get repairs done when requested.
Who did the work, the actual work at the properties that you managed?
I would do small sort of handyman stuff. If it was something beyond my capabilities, I would hire professionals. So for stuff like HVAC or plumbing, I hired professionals.
Tonight, I want to switch gears here for a second. The jury has heard about that Christmas party in 2018 and that Taylor and Thomas were on the deck when it dropped, when it felt like it was coming loose. Did the tenants tell you anything about that in 2018?
No, I did not hear anything about that in 2018.
How about in 2019?
No, I didn't hear anything about that in 2019 either.
Your Honor, I'm directing the witness and showing opposing counsel what has been previously marked as Exhibit 2. This is on page 58 of the electronic file. Mr. Knight, do you have a copy of Exhibit 2 in front of you?
Yes, I do.
Can you please tell the jury what this is?
This is the first time the tenants contacted me about the deck. It was sent on April 30th, 2019.
And is it a fair and accurate copy of that text message?
It is.
Your Honor, I move to enter Exhibit 2 into evidence.
Without objection, Your Honor.
May we publish, Your Honor? Mr. Wax, is this on my end?
No, Mr. Hammond, it appears that
Thank you.
we might have a technical issue again. So if we can stop the time, I think both parties agree to that.
Yeah.
My apologies again. I promise you guys, I never have had connection problems with Zoom from my home until today.
Yes, sir.
And so I lost connection, I think, when you were publishing.
Yes, Your Honor. Mr. Taft, can you put that up, please? Mr. Knight, looking at this screen grab, can you tell us who's who on here?
Yes, I can. So the messages from Alex Rios are in gray and my return message is in blue.
Can you read to the jury what Alex wrote?
I can. Alex writes, "Hi, Morgan. This is Alex Rios from 1414 Midvale. I wanted to mention again that the back deck of this rental continues to make creaking noises. As of today, April 30th, 2019, I saw that the county has open signups for free deck inspections. We wanted to inquire whether this is something you are willing to pursue for safety reasons."
And can you please read how you responded?
Yes, I responded, "Hello, Alex. Thanks for reaching out. I don't have a note that there have been any problems with the deck. I will check out the county website. Thanks."
When Alex asked you to get an inspection, did you do that?
Of course I did. I went to the website and saw that there was no inspection available until mid-May.
Well, the jury has heard that Pat Murphy scheduled 1414 Midvale for a May 20th inspection. After you learned that, what, if anything else, did you do?
I continued to research for other deck inspectors.
Were you able to find another one?
No, I wasn't.
And after you said that you would apply for the inspection, did the tenants ever get back to you about the deck or about safety?
No.
Or to ask for an update?
No.
Or to say, hey, we're going to have a party?
No, I was never told about any party.
You testified earlier that over the 2 years that the house was rented, the tenants contacted you whenever repairs were needed. Is that right?
Yes, they did a few times.
On any of the times that you were texted or otherwise asked for a repair, did that message include anything about the deck?
No, it did not.
And whenever a repair needed to get done, did any of the tenants say, hey, while you have someone here, would you please look at the deck?
No.
No further questions, Your Honor.
Your witness, Mr. Wax.
Good afternoon, Mr. Knight.
Good afternoon.
Sir, you showed us an inspection report from 2016. You said that you got that when you started managing 1414 Midvale?
Yeah, I got that after we first toured the property.
You told us that you relied on that inspection report, right?
Yeah, along with my visual inspection and some other things as well.
Some other things. Mr. Knight, you're saying that you did other things besides a visual inspection and this inspection report?
Like walking the deck, yeah, and checking the railings.
All right. Let's take those two different inspections one at a time. See if you should have relied on them. Ms. Evans, can we Your Honor, permission to republish Exhibit 10, which is in evidence.
You may.
Mr. Knight, this report says the property was inspected by Rory Gilmore, right?
Yes, that's what it says.
And that this inspection happened in 2016?
Yes.
So this inspection would have happened over a year before you started managing the property, right?
Yes, that's correct.
Mr. Knight, you don't know Rory Gilmore, do you?
No, I do not.
When you were relying on this report, you didn't know where Mr. or Miss Gilmore worked, right?
Nope, I did not.
Sir, you didn't know if Rory Gilmore was a licensed inspector when you relied on this report, did you?
Yeah, unfortunately, there was no license number on the report.
Can we zoom in on Rory Gilmore's name? Mr. Knight, you see where it says name and license number?
Yes.
Like you just told us. There's no license number there.
That's correct.
So this is the report that you relied on, right?
Yes.
You'd say this was good enough for you, right?
Yes, this report and my other visual inspection and my walking of the deck.
Well, let's talk about whether or not your visual inspection was good enough. Mr. Knight, you're not a licensed inspector, are you?
No, I'm not.
You're not a certified building official like your friend, Mr. Murphy, are you?
No, I'm not.
But you did tell us that you walked the deck, right?
Yes, I did.
Right before you rented it out, right?
Yes, before it was rented out.
You knew that this deck was 30 years old when you started renting this property, right?
Yes, original to the house.
So, sir, it's your testimony today that this 30-year-old deck seemed fine?
It did, yes.
That it didn't feel rickety to you?
No, I did not notice that.
Mr. Knight, according to you, this 30-year-old deck wasn't even creaking?
Not that I noticed, no.
You didn't see hundreds of nails attaching it to the house?
No.
According to you, this 30-year-old deck seemed completely safe, right?
Yes.
Mr. Knight, 2 years later, that deck collapsed and killed someone, right?
Yes, it did.
Your Honor, permission to republish what's already in evidence as Exhibit 1.
You may republish it.
I'll make something clear, sir. Your job was to manage this property, right? It
Yes.
was your role to make sure that it was safe and habitable for tenants, right?
Yeah.
You were still the property manager when this deck collapsed, right?
Yes, I was.
You were still the property manager when this deck killed Thomas Jordan.
Yes, I was.
Tonight, you didn't pay for a licensed inspector to inspect that deck in 2017, did you?
No, I did not.
You didn't pay for an inspection in 2018, right?
No, I did not.
You didn't pay for an inspection in 2019, right?
No, I reached out about getting a schedule. I had looked on the county website to schedule a free inspection in 2019.
Let's be clear, sir, those inspections, they didn't cost any money, right?
No, they did not.
Now, sir, you told us that you started researching private inspectors, right?
Yes, I did.
But it's your testimony that you couldn't find any?
Yeah, I did not have any luck.
So you were waiting for the free inspection?
Yeah, after not being able to find one, unfortunately, I had the deck collapsed, and I before the free inspection had gotten there. Yeah.
Mr. Knight, let's be clear. The reason why you didn't hire a private inspector is because you didn't want to pay for one, right?
No, that's not the reason why I didn't hire one.
All right, let's break that down. Hiring a licensed inspector usually costs money, right?
Yes, it does.
If they find something wrong with the property, that costs money to fix.
That's correct.
Mr. Knight, if they find something really wrong, something that makes that property unsafe, you might have to stop renting that property entirely, right?
That's correct.
You tell us that it's your job to keep your clients, the property owners, happy, right?
Yes, that's part of my job.
To keep the rent money flowing. That's how you describe it, sir, right?
Yes, that's part of my job.
Mr. Knight, in 2017 to 2019, you were managing 31 properties, right?
That is correct.
And you've been in business for over 20 years at that point, right?
Yes.
I'm looking for a number here, sir. In all those years, you managed all those properties. How many times had you hired a safety inspector for any of them?
I have never hired a safety inspector. Zero.
No further questions.
Redirect?
Yes, Your Honor. Your Honor, permission to republish Exhibit 10.
Yes.
Mr. Knight, on cross, they asked you a bunch of questions about the person who filled out that report. I want to ask, where does the report say it comes from?
So as you can see at the bottom of the document, it says that the inspection form was created by the SREC, and that's the Steelton Real Estate Commission.
Was there any other mention of the SREC on that inspection form?
Yes, the inspection report on the first page says that the inspection is subject to the SREC standards.
You can take that down, Mr. Taft. Thank you. They also talked about the money spent on inspections or repairs on this deck. Let me ask you, was the revenue at Mickey Terranova's houses high?
Yes, as far as I know, it was a college town and he was able to lease the properties at high rates.
And to your knowledge, would repairs have cut into your bottom line?
Not that I know of or was ever told. Rent was high enough that maintenance wouldn't have hurt his profits at all.
Nothing further, Your Honor.
Thank you. Thank you, Mr. Knight. You may step down.
Yes, Your Honor.
The defense may call this next witness.
Your Honor, the defense calls Alex Rios.
Mr. Rios, could you please raise your right hand? And sir, do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You may put your hand down. Counsel, you may proceed.
Mr. Rios, please tell the jury what you do.
I'm currently a law student at Steelton U School of Law.
Were you a student back in 2019?
Yes, but I was an undergrad. I was a senior at Steelton U.
The jury has heard that you lived with Taylor and Thomas at 1414 Midvale during that time. How did you meet your housemates?
Well, Thomas Taylor and I lived on the same floor of our dorm during our freshman year. We really hit it off, so we decided to move in together.
What was your relationship with them like?
I was good friends with them, but they ended up hanging out with each other more because I spent a lot of time studying.
Taylor Williams told us that you would call or text Morgan about any maintenance issues that the house
Objection,
had.
Your Honor. May I be heard at sidebar constructively?
You may.
Your Honor, as Your Honor clarified in pretrial, all witnesses have been constructively sequestered. As this witness was not in the room for Ms. Williams' testimony, it's inappropriate for counsel to refer to that testimony since this witness has been deemed by the court to be constructively not in the room.
I thought that I did not sequester the witnesses.
That was my understanding, Your Honor.
I may
No,
have misheard you, Your Honor. I heard you to say they would be sequestered. If I misheard, then I apologize.
Yeah, I did not sequester the witnesses.
Yes, Your Honor.
Okay, you may proceed, counsel.
Thank you, Your Honor. Taylor Williams told us that you would call or text Morgan about any maintenance issues that you had at the house. How often did you reach out to Morgan in 2019?
Only a couple of times, just about some minor maintenance stuff.
And when you reached out, how would Morgan usually respond?
Each time I told him we had an issue, he handled it immediately.
Now, the jury has also heard about a Christmas party that your housemates had that year. Were you there for that party?
No, I had already gone home for winter break
When did you hear about it?
when I got back from break.
And what did you learn?
My housemates told me that they were hanging out on the deck having a party when all of a sudden the deck moved like it was coming loose.
After learning that the deck had moved, what, if any, discussion was there about how it should be used, if at all, moving forward?
I remember telling Taylor and Thomas that we needed to be more careful when we were out there.
Did you ever communicate to Morgan that the deck had moved?
No, I did not.
From what you may have heard, did any of your housemates say anything?
Not that I heard.
Now, you told us Morgan sent people over to do maintenance for a few things over those next few months. Did you ever raise any concerns with those people that came by about the deck?
No, not that I remember.
And as far as you know, did any of your housemates?
No, not that I know of.
The jury saw that text between you and Morgan at the end of April. What was that about?
I told him the deck was making creaking noises and asked if he would schedule a county inspection for it.
And how did Morgan respond to your request?
Morgan responded and said he'd check out the county website.
We've talked about how it was your job to reach out to Morgan about any needed repairs as well. Did you ever make any requests for repairs on this deck?
No.
After you sent that text to Morgan, did you ask Morgan whether it was okay to keep using the deck?
No, I didn't ask.
What about confirming with Morgan whether it was going to be inspected?
No, I didn't confirm.
I got to turn to the May 11th graduation party. How long were you there at that party?
I was there all day.
How many other people did you see there?
Well, people were in and out of the house all day. It was an open house party. There were at least 100 people that passed through.
How did everyone eventually end up on the deck?
Taylor and Thomas wanted to take a photo with everyone at the party, so Taylor invited them all onto the deck.
And while those people were heading out there, where were you?
I was inside, grabbing a drink from the fridge.
What, if anything, did you say to Thomas and Taylor when they started bringing people out onto the deck?
I yelled out to them, "Yo, that seems like a bad idea."
Why did you say that?
Well, like I said, at that Christmas party, the deck moved with a smaller group of people on it, and there were way more people than that going out onto the deck at the grad party, so I was scared.
What happened after you tried to warn your housemates?
Everyone went onto the deck. I'm not sure if they didn't hear me or just ignored me, but they went out onto the deck anyway.
How many people did you see on that deck right before it collapsed?
Easily 40 to 50 people.
No further questions. Pass the witness, Your Honor.
Ms. Stebbins,
Yes, Your Honor. Could I have a moment to adjust my camera?
you may.
May I proceed, Your Honor?
Yes.
Good afternoon, Mr. Rios. Can you see and hear me all right?
Yes, I can.
I know we're on Zoom today, sir, so if at any time that changes, please just let me know, okay?
Okay.
I appreciate it. I want to start by talking about that Christmas party you mentioned just a moment ago. You weren't actually there for that party, were you?
No, I had gone home for winter break.
After you got back, your roommates, they told you about it.
Yes.
So, sir, you can't tell us firsthand what happened, can you?
No, I wasn't there.
You told us that on May 11th, 2019, you saw about 40 people on your deck. Did I get that right?
Yeah, somewhere around 40 to 50.
When you moved into that house, you spoke with Morgan Knight, the defendant's property manager, right?
I'm sorry, could you repeat that?
When you moved into your house, you spoke with Morgan Knight. That's the defendant's property manager, right?
Yes.
And Mr. Knight didn't tell you that deck had a weight limit, did he?
No, he didn't.
He didn't tell you that deck had a capacity or a maximum number of people who could safely be on it, right?
No.
A minute ago, you told us you thought having 40 people on the deck was a bad idea. Sir, your roommates, they threw a lot of parties, right?
Yeah, they had parties.
In fact, you'd say they partied most weekends, right?
Yes.
And a lot of weeknights too.
Yes, that's correct.
You usually weren't there.
No, I was studying in the weekdays.
So since you were studying, you can't tell us if they had 40 people on the deck at any of those other parties, right?
No, I couldn't tell you that.
You can't tell us if May 11th, 2019 was the first time there were 40 people or even more out on that deck, right?
That's correct. I couldn't tell you.
I want to talk more about how the defendant maintained that deck. You lived in that rental house for almost 2 years. Isn't that true?
Yes, that's true.
And during that whole time, it creaked when you walked on the deck.
Yes.
In fact, you'd seen nails that looked like they were connecting the deck to the house.
Yes, I did. I didn't really know what it meant, though.
That's a yes, sir. You saw those nails, right?
Yes, yes, ma'am.
You'd say the deck, it looked old.
Yes,
In fact, you'd say it was rickety.
that's correct.
It worried you.
It did.
It worried the three of you living there so much, you had conversations about the state of the deck.
We talked about it in passing.
You thought you needed to be more careful.
I did think so.
On the day of the party, when Mr. Jordan died, you were so worried about that deck. You didn't want to go out onto it, right?
I'm sorry, could you repeat the question?
The day of the party, when Mr. Jordan died, you were so worried about that deck that you didn't want to go out onto it. Isn't that true?
Yes.
Let's talk about whether Morgan Knight ever did anything to fix those issues with the deck. Sir, you think the defendant should have done something to fix the deck. Isn't that true?
That's true, but Thomas and Taylor should have known better as well.
Not asking you about Thomas and Taylor, sir. I'm just asking you about Mr. Knight. You think Mr. Knight should have done something to fix the deck, right?
Objection, Your Honor. This is invading the province of the jury. May we be heard at sidebar?
No, objection is overruled.
I'll repeat the question for you, Mr. Rios. You think Mr. Knight, the defendant, his company, should have done something to fix your deck, right?
Yes,
But after you moved in all the way through spring of 2019, well, the defendant hadn't done anything about the deck.
not that I had seen.
So when you learned the county was offering free inspections in April of 2019, you reached out to the defendant.
Yes, I texted.
You texted him saying you thought the deck should be inspected for safety reasons, right?
That's correct.
Your Honor, may we republish what's in evidence as Exhibit 2?
You may.
Mr. Rios, opposing counsel a minute ago asked you a lot about what Mr. Knight did or didn't tell you. So I want to just clarify what happened after you sent these messages. The defendant didn't call you to ask what was going on, did he?
No,
He didn't tell you an inspection had been scheduled.
no,
He didn't drive over to the house to make sure your deck was still safe, did he, sir?
no, the response is just the message.
He didn't ask to set up a time to meet with you to make sure he understood what safety concerns you had.
That's correct. He didn't set up a time.
In fact, sir, he didn't even ask you what safety issues you were talking about, did he?
That's correct.
Didn't ask you to explain?
Correct.
He texted back and said, I don't have a note that there have been any problems with the deck, right?
That's what it says, yes.
Thank you, Mr. Wax. We can take that down. And Mr. Rios, in the 2 years you lived there, you never saw the defendant fix your deck, did you?
No,
You never saw the defendant inspect your deck.
no,
In the 2 years you lived there, as far as you know, the defendant never sent anyone to inspect your deck, did he?
not that I saw.
Thank you, Mr. Rios. No further questions, Your Honor.
Redirect, Ms. Marr.
Yes, Your Honor.
May proceed.
Thank you. Mr. Rios, opposing counsel just asked you about seeing nails around the deck. Did you ever communicate that to Morgan?
No, I didn't think it was a problem or anything.
She also asked you about what you wrote in that text message we just saw, specifically about safety reasons. What is the only specific problem you articulated to Morgan about this deck?
That it was making creaking noises.
And to be clear, despite what words you may have used in that text message, do you remember mentioning creaking noises to Morgan before you sent this text?
No, I don't remember ever telling Morgan about that before this.
What about thinking the deck was rickety?
I never told Morgan that either.
Lastly, Mr. Rios, opposing counsel asked you about whether you think Morgan should have done something about the deck. Who do you believe also shares responsibility?
Objection, Your Honor, to 403.
I'm sorry.
Objection, Your Honor, to more prejudicial than probative. May I be heard?
You may.
Your Honor, I didn't ask the witness who he believes is responsible. I asked him if he thought the deck needed repairs. Counsel is asking this witness to assign responsibility. That misleads the jury and may invade their province, Your Honor, especially since the defense is asserting a comparative negligence defense today.
Ms. Marr?
Your Honor, they opened the door by asking this witness who they think should have done something about the deck. I'm simply asking who else they think might have been responsible for this collapse.
Ms. Marr, that's clearly two different things. One is asking based on notice of a problem. Your question specifically is seeking a legal conclusion. And to that extent, it is improper. The objection is sustained.
Yes, Your Honor.
You may proceed.
Yes, Your Honor. Mr. Rios, do you think it was a bad idea to have that number of people out on the deck after it had moved in December?
I do.
No further questions.
Thank you, Mr. Rios. You may step down.
And the defense rests its case in chief, Your Honor. No more witnesses.
Okay. Are counsel ready to proceed then with closing arguments?
Your Honor, the plaintiff would request maybe a 5-minute recess before closing arguments, if that's amenable to the court.
All right, and does the plaintiff reserving any rebuttal?
Yes, Your Honor, the plaintiff would like to reserve whatever time I have remaining at the end for rebuttal.
All right. We will reconvene, then we'll be in recess until 06 on the hour, whichever hour everybody's on.
Yes, Your Honor.
All right. Have all the jurors returned to the box?
I'm here, Judge. I cannot,
Yes,
camera,
Hazelton's
but I'm
here.
Johnson's here.
Juror Wexler, are you there? Okay, let's give him a few more minutes.
Yes, I'm here.
Okay, all right. Then it appears we are ready to proceed with the closing argument on behalf of the plaintiff.
Yes, Your Honor. And before I begin, in addition to admitted exhibits, may I display relevant portions of the verdict form and the court-approved jury instructions?
Yes, you may.
Thank you, Your Honor. May it please the court. It's April 30th, 2019. The defendant looks down at a text message from one of his tenants. Their deck is still creaking. They want it inspected for safety reasons. The defendant's actions when they got that text reveal what Thomas Jordan's life was worth to them. It wasn't worth booking an inspector immediately. It wasn't worth a call to ask what these safety concerns were. It wasn't even worth a trip to the house to look at the deck. His life wasn't worth a look. As the plaintiff, we had to prove that more likely than not, the defendant's negligence caused Thomas Jordan's death. We met that burden with 3 simple facts. The deck was dangerous. The defendant should have known that, but they didn't look. Let's take those one at a time. Fact number 1, the deck was dangerous. The members of the jury, this is that deck. You heard from one expert today, and that was a man named Pat Murphy. He runs the department that performs the very inspections the defendant never bothered to get. He told you most decks last 15 years, 25 if you're lucky. The defendant's deck was 32 years old. It had been weathered and worn and walked on for 32 years. And we know it was showing its age. Even the defense's own witness called it old, called it creaky, called it rickety. And our expert explained why. Folks, it was improperly attached to the house. Decks are heavy. It's important that whatever's attaching them to the house is strong enough to hold them up. Lag screws do that. But this deck was attached with nails. The defense says weight is what caused this deck to collapse. Yes, members of the jury, exactly. People stand on decks. Nails can't support people using a deck as normal. If the deck had been properly attached with lag screws, weight wouldn't have been a problem because that's what lag screws are designed to do. Folks, these tenants had been having parties for months without incident. And remember, the defendant never told them there was a weight limit or a maximum capacity. As Mr. Murphy told you, a deck attached with nails is a disaster waiting to happen. Which brings us to fact number 2. The defendant should have known the deck was dangerous. And that's important, members of the jury, because a landlord has to make repairs for which they have actual or constructive notice. Remember that, folks, or constructive notice. The defense has said over and over and over again, no one ever told me. He relies on his tenants. They asked Mr. Rios a lot of questions about, did you ever tell Morgan Knight this? Did you ever tell him that? Members of the jury, that doesn't matter. Because even if they didn't know, if they should have known. If a reasonable inspection would have revealed the unsafe condition, the law says they're just as liable. The defendant should have known in March of 2017 when they became the property manager. They knew the deck was 30 years old. They should have known in April of 2017 when their deck hadn't been inspected in over a year. The county inspector told them decks are supposed to be inspected annually. This deck was overdue for an inspection before they even rented it out. You might have missed it because he breezed by it so quickly, but I took a note. Mr. Knight told you that even the inspection report he did review, the outdated one from 2016, even that one recommended another inspection. Every possible source he looked at, folks, said he needed this deck inspected again. He should have known in June of 2017 when Thomas Jordan asked Morgan Knight if they would be willing to repair the deck. And all Thomas Jordan had done was walk on it. Alex Rios thought it was unsafe. And that's important, members of the jury, because with the one thing we know this defendant did do is walk on the deck. If two college students with no construction experience did the exact same thing, and even they knew it was unsafe, the defendant should have known too. But it doesn't end there. The defendant should have known in 2018 when it had been 2 years without an inspection, should have known in 2019 when it had been 3. And even if somehow they failed to notice all of those times, they definitely should have known on April 30th, 2019. Because that's the day they received this text message. Their tenants ask for a deck inspection for safety reasons. What's telling about the defendant's response is what they didn't say, what they didn't do. They didn't drive over to the house to make sure the deck was safe, didn't meet with the tenants to figure out their concerns. Morgan Knight didn't even ask what safety reasons. Think about that, members of the jury. This is at least the second time one of their tenants has asked for a repair or an inspection of this deck. Their tenants have safety concerns. And they don't have a single follow-up question? If the defendant didn't know there was a problem with this deck, it was because they were willfully ignoring it. To this defendant, his life wasn't worth a look. Fact number 3, they didn't look. Folks, no one disputes that. The defendant admits that in 3 years, they never had this creaky, rickety, 32-year-old deck inspected, not once. Which begs the question, why not? Because it costs money. Remember, the defendant's response when they got that message, I'll check the website for a free inspection. In other words, we're willing to keep our tenants safe as long as it doesn't cost us anything. That's their policy. The defendant has been in business for decades, and they have never paid for a deck inspection. This is the verdict form. You're going to be asked to fill this out at the end of today's trial, and I want to walk through it with you. The first question is whether the defendant was negligent. You're going to learn a person is negligent when they don't use what's called ordinary care. Ordinary care is what a reasonably careful company would do in similar circumstances. A reasonably careful landlord listens when the county inspector says decks are usually unsafe after 25 years. A reasonably careful landlord listens when the county inspector says decks need to be inspected every year. A reasonably careful landlord listens when their tenants say, please repair this deck, please inspect this deck. A reasonably careful landlord knows their tenants' lives are worth a look. On question 1, you can mark yes, the defendant was negligent. Question 2, did the defendant's negligence cause Thomas to die? And here, the law asks 2 questions. Was the defendant's negligence a substantial factor in his death? Folks, the defendant didn't fix the deck, and that deck killed Thomas Jordan. A second, but for the defendant's negligence, would Thomas have survived? If the defendant had paid for a deck inspection, a one look would have discovered those nails. We know that because not only did Mr. Murphy find them after the fact, the defense's own witness, Alex Rios, saw them just from walking around the house. One look would have saved his life. You can check yes to question 2. We've met our burden. Now, for every other question on this verdict form, the defense has the burden. Questions 3 and 4. Was Mr. Jordan negligent? Did he cause his own death? The defense says Thomas Jordan shouldn't have told 40 people to get onto that deck. Members of the jury, he didn't. Taylor Williams did. And then the defense says, okay, but he should have stopped her. But remember, they'd been having parties for months without incident. And the defendant never told them there was a weight limit or a maximum capacity. So let's get this straight. The defendant neglects this deck for years, refuses to make repairs, refuses to pay for an inspection, tells the tenants the deck is fine, and then blames them for using it? You can mark no. Thomas Jordan wasn't the one who was negligent. And no, Thomas didn't cause his own death. Question 6 and 7. Didn't Mr. Jordan assume the risk of his own death? To meet that, the defense had to prove Thomas Jordan fully understood the extent of the deck's danger. For Thomas Jordan to have fully understood the risk, he would have needed to know nails were unsafe. He'd have needed to know the deck was 30 years old, that it was already past its inspection date before he moved in. Thomas Jordan didn't know that. The defendant did. Because there's no way Thomas Jordan could have fully understood the extent of the dangers here. You can check no to questions 6 and 7 too. One look is all it would have taken. If they had paid for a professional to look at the deck when they learned it was too old. If they had paid for a professional to look when they knew the deck was due for an inspection, if they had paid for a professional to look when their tenants said, please have this inspected for our safety, Thomas Jordan would still be alive. We ask you to find Knight Property Management liable. Because to this defendant, his life wasn't even worth a look. Thank you. Thank you, Your Honor.
Mr. Heyman?
Yes, Your Honor. Court's indulgence while I set up the camera, please.
Sure.
Morgan Knight did not fail to look and did not cost Mr. Jordan his life. Morgan did what a reasonable landlord is supposed to do. Manage a house that passed inspection. Make repairs when asked. And set up inspections when they were requested. That's what these parties and what the law says is reasonable.
But what Morgan Knight was not required to do, and what he cannot be held responsible for, are fixing problems he was never told about. Solving issues he had no reason to suspect. And people using that deck in a way that went well beyond what it was meant for. Now, anytime someone brings a lawsuit, they can't just speak it into the air. They have to prove it. They can't prove to you what the judge will tell you is negligence. There are two reasons why. First, they didn't prove that my client acted unreasonably. And they haven't actually proved what caused this deck to collapse. Plaintiff told you that Morgan Knight had something called constructive notice, that without being told by the tenants or a professional inspection report of any dangers or seeing any signs of danger when he checked himself, Morgan still should have known that the deck was unsafe. But now you know that's not true. You know that because you've heard everything that Morgan Knight knew or could have known about that deck. Not a person ever said that it was dangerous. No one said that it was unsafe. Despite what plaintiff told you in their opening, no one told him about that Christmas party to tell him that the deck moved, that it felt like it was coming loose. No one said it was rickety, not when they paid the rent. Not when they asked for repairs on other parts of the house in 2019. Nobody told Morgan when he sent people over to do repairs in 2019. There was one communication in 2 years, sent 11 days before the accident. That text, it didn't say, hey, Morgan, the deck dropped over Christmas. We don't feel safe. Or, hey, Morgan, deck feels like it's coming loose. We're concerned. Or, hey, Morgan, we're having 50 or more people over for a party, and the plan is to hang out on that deck. Can you take a look? They told him, it's making creaking noises. Can you get it checked? Armed with that information, and that information alone, Morgan responded and then scheduled a deck inspection, because that's what the text demanded a reasonable landlord do. Morgan had no other reason to think that that deck was in danger of collapse. Morgan relied on an inspection report from a year before the house was purchased, an inspection that looked for the exact things their expert today said a good inspection should look for. He relied on it when it said no damage, no deterioration, no installation problems. He tried to tell you that Morgan didn't look at all, but members of the jury, Morgan Knight walked that deck himself before the house was purchased. Morgan Knight went underneath that deck before they rented it out. Nothing stood out then. That is the world of what Morgan knew or could have known about that deck from March of 2017 to April of 2019. He thought it was safe. And he thought so because he was using the tenants system that they had chosen themselves, and no one notified him otherwise. Alex told you that each time there was an issue, he texted or emailed Morgan, and Morgan responded. So Morgan didn't come by unless someone asked. But members of the jury, to some people, it can be reasonable to have a landlord who comes by your house once a week without being asked. To others, that's unreasonable. It's intrusive. There are landlords who say, hey, I'll stay out of your hair, but if you call me, I'll take care of it. There will be no instruction from Judge Yandel that says a landlord is unreasonable for using the system that the tenants chose, a system that worked. When there's a problem, call Morgan, he'll get on it. That system, it disproves their theory that Thomas's life was not worth a look. You heard no testimony of a money motivation on Morgan's part. In opening, plaintiff promised you evidence of a company policy to not do deck inspections, to not pay for deck inspections. In closing, they brought it up again, but they didn't show any evidence of that today. And members of the jury, we heard from Morgan Knight himself that he never felt any pressure to cut costs or not do repairs. Knight is a landlord who knows what he can do himself, who knows when to call in the professionals. Professionals he was not afraid to pay. A deck repair, a deck inspection, members of the jury, that requires professional eyes. So what did Morgan Knight do when Alex Rios texted him in April 2019 about that deck? He reached out to a deck inspector. And when that deck inspector could not come right away, he kept looking for other inspectors. He relied on the professionals to get this done. And plaintiff wants you to think that was unreasonable. But they have to show you that something more was required based on what he knew. Members of the jury, all he knew was that the deck was making creaking noises. You know creaking, members of the jury, it is the sound that my parents' steps would make when I snuck out of the house as a teenager. It's not the sound of a deck that's about to fall. Something else that they needed to prove to you today, one that you know they haven't. What caused the collapse? Look for a second at the expert that the plaintiff brought you. Members of the jury, Pat Murphy did not do enough to figure out why this deck fell. Remember, she said a bunch of things could cause a deck to collapse, but he didn't rule out any of those things. He didn't check for wood rot. He didn't check the weight limit on a deck of that size. Didn't talk to a single person who was on the deck that day to ask them how many people were there, how were people using that deck. He didn't talk to the firefighters to ask what position the deck was in when they got there, if they had moved that deck when they had to go get the body. Pat Murphy did not get the answers on May 12th, 2019, and he hasn't tried since. Why didn't a plaintiff ask him? You're an engineer. Why don't you run some tests? Or you're an engineer. Why don't you do some research? Instead, Pat Murphy looked. He took one picture and he leapt to a conclusion. Murphy is telling you that nails can't support the weight of people on a deck, but they have no idea when these nails were put in. They've never tested the weight limits on nails. And those nails, he said, could have been holding up that deck for 30 years. Their own inspector told you that decks could last longer if they're properly maintained. But then admitted that he didn't actually know if this deck was properly maintained. He couldn't tell you if it had annual inspections before 2017. Mr. Murphy claims that he's getting all the information he told you today from his own guide. A guide that he says he gave to Morgan, but they didn't even bother to show you those guidelines. So how can you judge if those guidelines are reliable? How can they expect you to believe that what the law requires for Morgan to have gotten the deck inspected once a year when those guidelines were not the law? Were not codified. And really, members of the jury, even if Pat did give those guidelines to Morgan, what would Morgan or anyone in Steelton have learned from them? Those guides do not say, check for lag screws in the ledger board. They don't say, check for bolts. They don't even say, make sure there aren't nails in there. This is the expert that the plaintiff decided to bring to court today. An expert who plaintiff's lawyers spent a lot of time trying to tell you their methodology. They asked, and I wrote this down, they asked 6 questions about the methodology they used in this case. And methodology, members of the jury, that's just a fancy lawyer word for what you did to come to a conclusion. So what did you learn they did after those 6 questions? They looked and they made up their mind. And because of that, plaintiff has not met their burden. They haven't shown that Morgan Knight acted unreasonably, and they have not shown that Morgan's actions caused the collapse. Because of that, you now know what the right answers are. Question 1 asked you, was Knight Property Management, LLC, negligent? Morgan Knight cannot be negligent for doing what a reasonably careful landlord would have done in his situation. If you find that's true, we're done, we go home. However, if you find that Morgan was in any way unreasonable, you got to move on to question 2. Question 2 asks, was Morgan Knight's negligence a proximate cause of the decedent's death? The answer to that question has to be no as well. Their expert still cannot tell you why this deck fell. But members of the jury, because the plaintiff brought this suit, I now have to tell you the whole story. And the law has this rule called comparative negligence. And as my co-counsel stated in opening, it is the only affirmative defense we're bringing here today. What comparative negligence means is that even if you think Morgan did anything wrong and that they somehow proved how this happened, you must also consider the decisions that Thomas made and ask whether they were unreasonable. What we're about to talk about is uncomfortable, but we need to talk about the hard truths in this case. Facts that they can't deny and facts that you must consider. Here are those facts. Thomas Jordan was on that deck when it moved, when it felt like it was coming loose, December of 2018. When it felt that way, just 10 people on it. Thomas Jordan never told Morgan Knight about that. A few months later, Thomas Jordan hosted a graduation party with 50 to 100 people. They invited everyone from that party onto the deck. Thomas Jordan could have taken that photo inside in the backyard, but he chose to take it on the deck, where all those people bunched up against that railing. And even though Taylor told him not to, Thomas chose to go under the deck. That cannot be called ordinary or reasonable care. What that is comparative negligence. And because of that, we now know that the answers to questions 3 and 4 are yes. You've now heard the plaintiff's case, but just like Pat Murphy's investigation, there are simply too many questions left unanswered to find for them. Now, anytime a lawyer gets up and speaks to a jury, they owe you clear answers to the tough questions. Hold me to that. Hold the plaintiff to that as well. In a moment, I'm going to sit down and they will stand back up. When they do that, remember what you heard here today and make them answer the tough question in this case. that deck moved when it felt like it was coming loose and no one told Morgan, how can his actions be called unreasonable? When that answer comes, if it comes at all, and it doesn't make sense, tell them that. Because although they get to speak to you last, members of the jury, you get the final word. Or in this case, the final two words. Not responsible. Thank you, Your Honor.
I'm sorry, Your Honor. I think you're muted.
You would be correct. Rebuttal?
Yes, Your Honor. May it please the court?
Yes.
Today on the stand and just now in their closing argument, opposing counsel and Mr. Knight kept saying, he didn't know, I didn't know. An opposing counsel asked how Mr. Knight's actions could be called unreasonable when he didn't know the deck had moved. I want to be sure to answer that. Because Mr. Knight never hired a safety inspector to tell him what he didn't want to hear, he can get on that stand and throw up his hands and say, well, I just didn't know. The law tells us that's not good enough. Landlords don't get to choose to never hire an inspector and then bury their heads in the sand when something goes wrong. And Mr. Wax, can we put that timeline up again? Opposing counsel just showed you this timeline. And I can't help but notice that while it's labeled what Morgan knew and did, there's a lot missing from this timeline. First of all, it's missing literally years of time. You can't even see 2017 on this timeline. That's because opposing counsel needs you to forget that Mr. Knight didn't have just a few months. He had years to get this deck inspected even once. What's not on this timeline is Mr. Jordan asking Mr. Knight for repairs in 2017. What's not on this timeline is that Mr. Knight knew this deck was 32 years old and overdue for an inspection, that he knew decks need to be inspected annually. That in 2019, he was being asked to inspect this deck for safety reasons. And there's something else missing from this timeline. It's ironic. This is labeled what Morgan did. Because you might notice, even defense counsel can't put a single thing Morgan Knight actually did to keep this deck safe on their own timeline. Opposing counsel said how tragic this case was. They said it in their opening, and just now they said it was uncomfortable to have to talk about. If the defendant had cared half as much as his lawyers do in court today, Mr. Jordan would still be alive. Find the defendant liable. Because to this defendant, his life wasn't worth a look. Thank you. Thank you, Your Honor.
Thank you, counsel. So the jurors will be instructed, and we will retire and be on recess. I would say 10 or 15 minutes. I'm looking for guidance from AAJ here for deliberations.
As your order, Judge.
Yeah, how about, it's 6:41? How about 10 minutes, 6:51. We will return.
Okay.
Yes, Your Honor.
Okay, all right. Thank you.
Okay.
Hey everyone, we're just waiting for our judges to submit our ballots. And judges, if you could also send me that email that we had talked about earlier, we will let everyone know when the ballots are in, and then you can proceed to feedback.
Jen, I already submit my ballot and send the email.
Perfect. Thank you so much.
I can turn on the camera. Apparently the host closed my camera and I can open
Okay.
it. So
I'll let Clark know once we have all the ballots. I'll have him turn on all the judges' cameras or turn off that function where people can't.
Okay, perfect. Thank you.
Thank you. Okay, everyone, all of the ballots are in. So if everyone would like to turn their cameras back on, the judges can go ahead and give feedback. There is a protest right now that does not affect the judges. So you can go ahead, but just so everyone knows, there might be a slight delay in announcing the final winner, and everyone can just hang out here if they want to wait for the announcement. Otherwise, afterwards, the judges are free to go. And I want to thank you again so much for giving up your Sunday evening to judge this competition. I hope you enjoyed it, and I will turn it back over to you, Judge Yandel.
Okay. Well, as soon as the jurors get on camera here.
I can turn on my camera, Judge.
Okay, that's fine. Mr. Wexler, are you there?
I'm here, but I can't turn on my camera.
Okay.
All right, Clark, could you allow everyone to turn their cameras back on? Sorry, I know we had that as a setting.
Right. Okay, I'm here. Thank you, Jay.
Okay, Mr. Wexler still there?
I'm here.
Okay. Okay. Just at the outset, I just want to seriously congratulate all of you and just say how phenomenal of a job you all did, and that is not puffery. I'm serious. You guys are all on your way to being very skillful and effective advocates, and so you should be excited. I'm going to defer to the jurors initially for their feedback, and then I'll bring it home.
May it please the court, Peter Wexler, I'll say a few words. This is the fourth round that I've judged, and like the finals of the NCAA basketball tournament, it was the most difficult. You were all great. A few comments. Opening statements for plaintiffs are the most effective when you become a storyteller, a spellbinder. Those are the most effective opening statements. For the defendant, apologies in death cases are very difficult, but there's nothing wrong in saying the defendant is sorry that so-and-so was killed on our property, but the evidence will show that we did everything possible to prevent that. It's a difficult thing to do, an apology. Cross-examination were good on both sides. It was good because cross-examination is the time for the attorney to talk and the witness to say yes or no. That's it. And I think you all did a very good job on that. You'll also, in closing, use the jury, not only the jury instruction, but the jury verdict form, which is very, very effective. You should always use that. And I think the defense counsel, and you got to be very careful about summarizing testimony, because the only thing that I heard, unless I didn't hear it all, was a witness saying there were 40 to 50 people out on the deck. And I think you said it was 50 to 100 people. That may not have been in the evidence, but it wouldn't have made a difference anyhow. So be careful with that. Anyhow, you all did great. And it was a privilege for me to take the time to be part of this. Thank you.
Mr. Cruz Perez.
Thank you, Your Honor. I concur with Brother Counselor Wilchers. You did a great job. This is my 5 or 6 competition. Everyone did a great job. All right, it's a pleasure and it's an honor to be here with you. You are the top of the top. So my comment is, please, as good as you did here, do it in real life. You are the future of the profession. So please do a great job in real life. We will be grateful for that. We need you, right? So good luck. Thanks, Your Honor.
Juror Woods.
Fantastic job, students. Amazing. I would say this is my one comment. Well, first, your demeanor and your advocacy is amazing. My one piece of advice is there were a number of times when the judge was giving you instructions and you spoke over her. Just give it that couple of seconds and let that happen. And then part B of that is the way that you all kept pushing despite getting ruled against. Keep doing that. So don't talk over the judge. Let them speak. But when you have to advocate, go ahead and go right back in there. They make a ruling, you're done. But before that happens, you keep going just like you did. And that's the sign of a really good advocate. Respectful, but still advocate. Fantastic job.
Juror Hazelton.
Yes, thank you. Each of the advocates, the students, were excellent. There was a couple of things, in particular, a couple of phrases that I really liked when they were bringing out something that was harmful. I think it was Sarah that said, I want to be upfront with the jury. And let me ask you this question about the drinking. That was just a very nice way of doing it. And at the closing about the caring, I loved the comment, because I think you could use this on almost any trial. If the defendant cared half as much as the lawyer did, we wouldn't be here. I mean, that's something I could almost use, put in my bag of tricks. That was fabulous. I also had an opportunity yesterday to judge the team that was the defendants. And I'm saying, like, they were fabulous yesterday. They were fabulous today. They really, I got to see them do both sides of the argument, and very tough litigators. So it was an honor to be a judge here, and you have a great future ahead of you.
And Juror Johnson.
Thank you, Your Honor. I've seen one of these teams earlier today, but I want to congratulate both of the teams. My personal experience with this competition goes back to 1986, first as a competitor, then a coach for about 10 years, and since then, a judge off and on. I guess this is the first final round that I've seen or been a part of since before all of you were born. That would be back in 1991. So congratulations to all of you. The professionalism, the ability to ask questions, all of the fundamental skills are there. But this is a starting point for each of you. And frankly, the time and effort that you have put in and the investment that your school and your coaches have put into each of you really puts you out ahead of your competitors, whether it's at your own school or other schools. But you've got to keep working at it. You've got to keep building your skills. And as I mentioned in the semifinal round today, I think the two places that you can work going forward is in how you frame the issues and how you sequence the issues and presenting them to the jury. You've got to remember who your audience is. They have no knowledge of the facts. You can't overwhelm them with facts. You've got to break it down and build it point by point until they can understand what is going on. So from the plaintiff's side, we'll actually back up. On the evidence, I noticed that there were no stipulations this round. In the earlier round today, most of the evidence was stipulated to. But for some reason, there was not a stipulation on pre-admitting the exhibits in this round, but there were no objections. So my thought is I don't know, you don't get points for laying predicates. It's good to know it. You got to be able to do it. But the ability to use exhibits at opening statement, I think, outweighs what you might get in style points for laying predicates. That's point one. Point two, you can use show and tell in opening statement. More questions showing me things helps me understand. And I think that's true for jurors as well. On the plaintiff's case, the things I struggled with the most are these, and this is for future reference in real practice and other competitions. I never saw the industry standard. To me, the industry standard is the rule. And the rule was never shown to me. And I think the reason is there's not one in the problem, if I remember correctly. And that really presents a problem for the plaintiff. Secondly, the fasteners discussion. There are exhibits that show the fastener and show how it works. Why those weren't used, I'm not sure. But it would have been helpful to see rather than just talking about it. And then the property guidelines, again, I'm not sure that that was shown or used as much as it could have been on the plaintiff's side. I think one of the other things that you can get in the habit of doing is trying to compare where each of the parties are on given points in the case. So a timeline or a comparison chart focusing on what the plaintiff said happened and then what the defense says happened would have helped sometime before the closing argument. On the defense side, Mr. Heyman, the voir dire this time didn't quite work as well as it did the earlier round. The earlier round, I agree with you. I think the witness had gone outside the record and had extended himself a little beyond the tips of his skis. But this time, I don't think it was quite there, and you weren't ready for that. So if you're going to try to blow up a witness, you got to make sure that you've got the ammunition to do that with. Also on the defense side, it's in real life, it's really dangerous to blame kids. And to hang your hat on a party defense, I think is dangerous in real life. And the fact here, if you're saying that you were only warned 2 weeks before, the problem with that is that in those text messages, what the defendant should have done was say, stay off the deck until we get it inspected. I think this was a dangerous case from the defense side. And it looks like y'all went all in rather than trying to share some of the blame. But blaming totally the plaintiff here in real life, I think would be a really dangerous move. Ms. Stebbins, your rebuttal was great. You just ripped them up there at the end. You took their timeline and you used it against them. That's great advocacy. Another thing that I wasn't quite sure why you did this, but every time you get a chance to try to frame the debate or narrow the issues, you should try to do it. There were no motions in limine today. I've judged hundreds of mock trial rounds and I've just hardly ever seen no use of the motions in limine at the beginning of a round. And then neither team went for the judgment as a matter of law. Plaintiff, the defense has the affirmative defense. Try to knock out their claims. And so, and again, from the defense side, whether or not the plaintiffs really got the expert that they need to get over the finish line, that's a tough deal. So the point of all of that is when you get out in the real world and you get beyond the fiction of mock trial, you got to really focus on checking off every evidentiary box, because not only do you have to get past the gatekeeper, the judge, not only do you have to persuade the lay people on the jury, but you've got to make your record for the Court of Appeals. Great job, everybody. Keep up the good work.
So I pretty much would echo all of the feedback and comments from the jurors. I do want to briefly add just a couple of things. One of the things that stuck out to me, and maybe it's because of what frankly has been front of mind as to what I see lacking or an issue in my courtroom every day, is the denigration of civility and professionalism with counsel in the courtroom. Unfortunately, I think that their counsel's conduct in, not everyone, but more frequently, is reflecting sort of the tone that we see in society and in our country in general. It's just kind of nasty and rude and overall combative. And I've had to check counsel for that. You all gave me hope today. Although when I start this trial tomorrow, I'm sure I won't be able to hold on to it. But you conducted yourselves with that degree of professionalism and civility that I think is appropriate, and that I hope and trust that you will continue to do when you actually begin advocating. I would be excited to see any one of you standing in front of me in the courtroom. You are, again, very skillful, professional advocates. The only other couple of things I would point out, the other thing you guys did really well, that frankly you could teach some lawyers, is that you really understood the concept of cross-examination. You effectively used leading questions and you understood what that was about. You know, frankly, if you're using open-ended questions on cross-examination, you're giving away the game. You guys didn't do that. You controlled the story that was being told. You effectively used cross-examinations. I would make two comments, however. On the one, sometimes the style, the cross-examination style where you just you kind of put the statement out there. It is the lawyer's time to testify, but you just kind of put your testimony out there without couching it with the question, and you kind of use your voice intonation for that. I think sometimes it gets lost in that. In other words, rather than just, for instance, if you on cross-examination said, you said, you didn't come out and inspect, punctuate that with did you, make sure that you end it with the question so it doesn't get lost in the translation. And really, so you don't draw an objection that you're just testifying, even though you kind of can on cross-examination. The only other comment I would make on your phrasing of questions, try to stay away from using gratuitous statements to introduce your question, whether on cross-examination or direct examination. In other words, the statements where you want to make sure the jury knows where you're going, so you tell them where you're going before you answer the question. If you want to throw a couple of those in there and emphasize it when it's about something that is particularly beneficial to you or damaging to the other side, throw one or two of those out there. But it should be limited. And it really is a question that if it had drawn an objection, I would have sustained it. But beyond that, you guys are awesome. You did a really, really good job.
Thank you all for your time. And thank you to our opponents. It was a fun round.
Agreed on all fronts.
Thank you, everyone.
Good luck.
Everyone, well, we have our winner and we have our parliamentarian, John Bay, here to make our announcement. So let me just spotlight you, John. There we go.
Hi, I'm John Bay, parliamentarian for AAJ and one of our national officers. And I want to say thank you on behalf of AAJ and all the officers for all the hard work you all have put in this competition. I've judged some rounds and I've seen some amazing advocates. And I know that this was really close. And there were two amazing teams here. But with that, well, before I announce the winners, I also want to remind everybody that there's a happy hour on Wednesday at 7 p.m. and you can RSVP to that by emailing Jen Rafter. But with that, I'm going to announce best advocate and then I'm going to announce our winners. And first, our best advocate was Sarah Stebbins from UCLA, Team 119. And our overall winner was Team 119 UCLA. Y'all both did an amazing job. Thank you so much.
Thank you all so much.
I think
Congrats
that
to
is
all.
everything. Thank you all so much. Congratulations.
Congratulations to everyone.
Congrats, kudos to everyone. Great job.
Congratulations all. Ms. Rafter, is that a wrap for us or you need us?
That is, thank you all